I am also an executive Ninth Circuit Survey editor of the Golden Gate University Law Review. And my note is entitled Jones v. Davis and the Critical Issue of Time in California's Capital Punishment System. And I am here tonight to talk to you about my interest in this topic and share a portion of my note with you. And I truly hope, like as Kat mentioned, that you'll take the time to read it. So I wrote about California's death penalty because it's something that I'm extremely passionate about. My interest started as a 10-year-old when friend of a friend, Polly Klass, was abducted from her home and killed. I lived in a small town between where she was abducted and where she was found. So in the December of 1993, my mom and dad and I went up to the memorial site, and we actually placed our angel Christmas tree topper at the site in memoriam. My interest peaked again when I heard world-renowned anti-death penalty activist, Sister Helen Prejean, speak to my high school. And years later, when I started law school, I saw this as an opportunity to explore my interest further. The case that is the focus of my note is Jones v. Davis, and it exemplifies the problem of excessive delays in California's capital punishment system for both supporters and protesters. After Ernest Dwayne Jones was sentenced to death, the victim's daughter declared in the courtroom that the sentencing was a hollow act because executions are rarely carried out in San Quentin. This is the same argument that Jones made before the Federal District Court and the Ninth Circuit Court of Appeals. And more than 2 decades later, as Jones continues to sit on death row, the Miller's fear has become a reality. Jones' death sentence has transformed into life in prison with the remote possibility of death. It is my position that the Ninth Circuit should have affirmed the district court's ruling and invalidated the state's capital punishment system. In 1995, Jones was sentenced to death after he sexually assaulted and murdered Julia Miller, his girlfriend's mother. And in 2014, Judge Carney issued the order, the order declaring California's death penalty unconstitutional and vacating the petitioner's death sentence after Jones petitioned for writ of habeas corpus and argued that his death sentence was unconstitutional because the delays in the system rendered it gravely uncertain when or whether the execution would ever be conducted. Bless you. The court said, where the state permits the post-conviction review process to become so inordinately and unnecessarily delayed that only an arbitrarily selected few of those sentenced to death are executed, the state's process violates the Eighth Amendment. Fundamental principles of due process and just punishment demand that any punishment, let alone the ultimate one of execution, be timely and rationally carried out. The California Attorney General, on behalf of the Warden of San Quentin, filed an appeal with the Ninth Circuit, arguing that the delays were part of the careful, individualized review that allows death row inmates opportunities to challenge their convictions. Almost 23 years to the day that Mrs. Miller was murdered, the Ninth Circuit heard oral arguments for the case. And it is my position that the Ninth Circuit should have affirmed the district court's holding for 3 main reasons. 1, citizens are losing confidence in the capital punishment system, which undermines the punishment's deterrent effect. Capital punishment is a critical issue for the state, and Californians and death row inmates alike must look to the judiciary for relief. And 3, the Ninth Circuit avoided the constitutional issue, and in doing so, the court deepened the problems that the defendant and the district court sought to alleviate. Now, I will briefly discuss some of those arguments. Hopefully you can read them in more detail later. But as part of my research, I often reviewed statistics related to death row inmates on the California Department of Corrections and Rehabilitation's website, where that information lives. I noticed that the numbers were frequently changing, often enough that I can tell you today that during the writing of my note from June of 2015 to November of 2016, 4 inmates on California's death row have died. 1 died of natural causes just days before Jones's case was heard before the Ninth Circuit. Another was executed in Virginia in the same year, and 2 died of natural causes in 2016. I can also tell you that since this note went to publication in November, another man has died on death row, and it was not from execution. Californians have unsuccessfully sought answers from the legislature and must now seek relief through the judiciary. Those awaiting execution are confined to using the judicial process for relief, which underscores the need for a fair and predictable judicial process. Judge Carney's order holding California's death penalty unconstitutional provided the answers that the state legislature has failed to produce. Yet the Ninth Circuit reversed the order, ostensibly creating more litigation, more unnecessary delays, and allowing the system-wide problems outlined by Jones in the district court to worsen in our state of California. The Ninth Circuit avoided the complex issues and ramifications of invalidating capital punishment in our state. The court stated that, quote, Jones remains free to seek relief through other means, including the state courts. However, there are two problems with this suggestion. First, the court used arguments related to judicial economy to explain why and how they came to decide this case and to reverse the federal district court's decision. And in suggesting that Jones return to the state courts, the Ninth Circuit suggests that Jones must start the process all over again, which contravenes any idea or any understanding of judicial economy. Second, the implication is that Jones has another alternative regarding his unconstitutional delay claim. He can just give up. This implication is deeply problematic because it suggests that Jones cannot ever prevail, and thus this discourages his pursuit of future legal claims. The court itself states that the post-conviction review process is in place to secure the rights of inmates on death row potentially facing execution. However, the sentence of death is in a class by itself and must be treated accordingly. Anyone, let alone the courts, should understand that those facing the ultimate punishment may use every means available to fight for their lives. And ironically, the one avenue available to them, maybe the most effective, is the very system that sentenced them to death, rightly or wrongly in the first place. I just have a few people to thank. First, again, and I'll echo what Elizabeth said, which is I just want to say thank you all for coming this evening and listening to us. The Ninth Circuit Survey is the culmination, as Elizabeth said, of countless hours of work. But I also want to thank, like Elizabeth said, the law review staff, past and present. I see Jesse is here. I can't thank you enough for selecting my note for publication. My note was made better by the current staff and by everybody who worked on it, especially Cara, Alex, and Mary, who's not here tonight. Kat Alfonso, you heard from her earlier. She's my dear friend, and she encouraged me to apply for law review at a really difficult time in my life when I just didn't think I could handle one more thing. And to Professor Christensen, who is my faculty mentor. He's actually not here tonight. Currently, he's actually teaching and writing about constitutional law in Spain as a Fulbright scholar. He always made time for me, and he provided thoughtful feedback, and he always raised the level of conversation when we discussed my note. He inspired confidence in me, and without him, this note would not be what it is. To my mom and dad, Brad and Pam Simmons, who's sitting in the front, congratulations on celebrating your 42nd wedding anniversary yesterday. This note was possible because politics and religion were never taboo topics in our household. And a special thank you to my mom because you always talked to me openly and honestly about things like polyclass, about the death penalty, and you took me to see Sister Helen Pashon. And to my husband, Giancarlo Varanini, he's an expert in his field, and he's been a successful writer for more than a decade. He's been quoted in the New York Times, he's appeared on CNN, and his Q&A with Napster creator Sean Fanning in the 90s actually was cited in an amicus brief before this very court in Grokster. His writing was something that I have always inspired to, so I thank him for his love and his support and his encouragement, and this note would not be possible without all of you. So thank you very much.